and welcome to the first of our videos following the 2020 Mad South Carolina Court Monitoring Report, where we focus on the recommendations and focus areas coming out of our report. In the earlier video, if you didn't see that, we went over the basic data and kind of why we do court monitoring. But in the first of these next 7 videos, we want to get into what we think South Carolina should look at and do differently because of this. And this one specifically, we want to focus on the issues of refusals. Of course, we named the report Refusal to Change. Now, we had 2 reasons for doing that. One was because a lot of the problems that have to do with DUI prosecution and adjudication issues are not new. South Carolina's been dealing with these for a long time, and that's why we said we seem to be refusing to change and we need to do differently. But also we chose that title specifically because we need to focus on the issue of what happens with what we call refusals in our state, because it's one of the bigger problems and frankly, one that people don't talk about as often. So when we say refusals, what we're referring to is the fact that when you get a driver's license in South Carolina or any other state, part of that agreement is you agree that if an officer suspects you of impaired driving and asks you to provide a sample, breath or blood, that you will do so. However, we also allow that if you, at the time of the request, you also can refuse. But since you're not doing what you agreed to do, there is a penalty, an automatic 6-month license suspension. But that can be appealed. And so basically people the next day can go get a temporary alcohol license from the DMV for $150 and basically have their driving privileges restored. So you really don't even have that immediate penalty of losing your license because there's a way to keep driving until that hearing. Now, some people lose that hearing, some people win, largely because if the officer is unwilling or unable to come testify as to why they made the arrest and that they did everything by the books. So once again, there's a chance they may never face the suspension, even though they clearly did what they were, said they wouldn't do, which is to refuse. So that is a major issue, we think, by itself, the fact that already there's not a lot of teeth to that law. Add that to the fact that if you're found guilty after refusing, which certainly can happen, you will actually face the lowest of all the possible DUI penalties. So in our state, we have penalties if your BAC is 0.08 to 0.10, 0.10 to 0.15 or above. If you refuse and are found guilty, it's assumed you had the lowest of all those BACs. So you're probably already thinking to yourself, wow, it looks like we practically encourage people to refuse. And you can argue that's essentially what our law does. In fact, we have a 42% refusal rate. That's extremely high. It's been going up over the years. Unfortunately, the only quality data comparison point we have for the rest of the nation goes all the way back to 2011, which was 20%. So there's reason to believe this issue has gotten a lot worse or is a lot worse in South Carolina. But we think refusals is definitely something that needs to be looked at. In fact, just to add to it, one of the problems that officers and prosecutors from all of the areas where we had these local conversations during the year told us there's a growing trend of what they call double refusals, meaning people would do the field sobriety test on the side of the road, and then they might refuse to blow into the data master machine. Now we're hearing more reports of people refusing to do either. So going well out of their way to make sure that the officer has no additional evidence of which they may incriminate them. And so we need to really look at this entire issue of how our statute is written, where we're essentially encouraging this behavior. However, we do have one very specific recommendation as well. So with the ignition interlock bill that we're trying to get passed in 2019 and 2020, that bill actually on the Senate side did include language that would say not only should everyone convicted of a DUI get an ignition interlock device, but also makes it a condition to get that temporary alcohol license. So if somebody refuses, get the license suspended, but they want to get their driving privileges back as they currently can do, and right now it's only costing them $150, we're saying they need to go get an interlock installed on their car, then go get that temporary alcohol license. It should be a condition. And again, since they violated what they said they would do, we think that's reasonable. So actually that passed the Senate. It was in the Senate bill that passed on a 40-to-1 vote, which should clearly indicate this was not, a major problem area. It was running into some opposition on the House side, and unfortunately with COVID kind of shutting things down, the process really didn't play out on the House side, but it was looking like that was going to get pulled out of the House version. We're hoping as that legislation gets reintroduced in 2021, we can keep that piece in along with the all offender ignition interlock piece. We think it will, create some actual teeth to our refusal law. So now if somebody is thinking about refusing, they need to realize there's an actual something that's going to happen to them. They're going to have to go through the inconvenience and cost of getting that interlock, which again is not about cost and inconvenience for all of us on the roads. It's about making sure that person is making the right decisions and blowing sober before their car will start. So refusals are something we need to look at in our state. Or if for a long time we've been refusing to change, we need to change about our refusals. Thanks for watching this video, and I hope you'll stay tuned to the rest as we talk about the other recommendations and focus areas coming out of this important work. Thank you.